Welcome. This is great to have you all here at this 4IP Council's webinar, which is called The Big Steal, Ideology, Interest, and the Undoing of Intellectual Property. My name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I will be your host today. So as you certainly know, 4IP Council is a not-for-profit organization. What we do is we focus on the link between IP and innovation. Our mission is very simple. We need to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find a wide variety of free materials. For example, you have studies, summaries of relevant papers, such as the summaries of the book, The Big Steal, recordings of our webinars and podcasts, interviews with inventors, entrepreneurs, and IP disseminators. We also produce easy to digest content such as the SME's Corner, which is especially tailored for non-IP experts, SMEs, and startups. We also have an area on our website called IoT and Cellular Standards Made Simple. The goal is to make sure that you can easily find and understand the benefits of standards and the Internet of Things across different sectors. Check it out to learn more. We have recently launched a new area called AI and intellectual property rights, which guides, videos, papers, and interviews to help you understand how AI is revolutionizing the way we live, work, and create, but also the pressing questions raising about IPR. You can follow us on most of the platforms on like X, LinkedIn, YouTube, and Instagram. Our handle is always the same, 4IP Council. There you can find news like IP events, resources, interviews, the latest research papers that we have published, and the future webinars. Without further delay, it is my great pleasure to introduce our speaker for today's webinar, Professor Jonathan Barnett. So Jonathan Barnett is a professor at the University of Southern California, Gould School of Law, and director of the Law School's Media, Entertainment, and Technology Law program. He specializes in intellectual property and competition law and policy, with a focus on the empirical study of transactional structures in information technology markets. He has published widely in scholarly journals and recently published Innovators, Firms, and Markets, the organizational logic of intellectual property, which is Oxford University Press 2021, an economic and legal history of US technology markets and innovation policy. Before academia, Jonathan Barnett practiced law at Cleary, Gottlieb, Steen, and Hamilton in New York, specializing in private equity and mergers and acquisitions transactions. As you can guess, he just wrote and published a book this year, which is called The Big Steal, which I highly recommend. I found it really impressive. That's a lot of work, and that's what this webinar is about. A final remark, you can ask directly your question to Professor Barnett using the Q&A tool that you can find at the bottom of your screen. Live questions will be taken after a first set of questions that we have prepared. So please don't wait, just post them and we will take them right away. But Jonathan, let's get started. I mean, what motivated you to write this book? Can you situate the book in the policy space on IP rights in the courts, Congress, and antitrust agencies, and how that's shifted in the US over the past 2 decades or so?
Yeah, first of all, great to be here, and big thanks to 4IP Council for putting together this webinar, putting together the chapter summaries. The reason I wrote this book is exactly to do those kinds of activities. I want to get the message out And the message is the story in the book. And the story in the book is how the IP system in the United States over roughly the past 2 decades has been captured and it's been distorted. It's been captured and distorted by firms that use a particular type of business model, which I call the giveaway business model. Those are the platforms that we're familiar with. I recognize in the book that platforms have an important role to play in digital ecosystems, but so do many other stakeholders, both on the tech side of the digital economy and the content side. And the weakening of IP rights over the past 2 decades, which is systematic, it's consistent, it's in almost every branch of government. Virtually any opportunity to weaken IP rights, government entities have been convinced by arguments that this is in the public interest. The result today is that we have an IP system that serves the interests of what I call the aggregators, but it underserves the interests of the innovators on the tech side and the creators on the content side. And that's not a good recipe for a sustainable innovation ecosystem over the long term.
Wow. Okay. So, you, when you talk like this, I feel that it is gloom and everything is going down. But, in the book, you talk about an accidental alliance of big tech on the one end and academia and advocacy groups on the other end in favor of weakening IP rights. I mean, that's huge. But that seems like a case of strange bedfellows. How and why did it arise?
Yeah, so it's easy to understand why platforms want IP rights to be weak. And let me just make that clear if it's not obvious, right? So just to give you an example, why does big tech, why does a platform prefer IP rights to be weaker? Because after all, they do invest, many of them invest a lot of money in R&D. But if you're a site like YouTube, right? You're like any business. Businesses have inputs. They have materials they need. Well, the material that YouTube needs is content, right? The more content they have, the better content they have, the more users they have, the more ads they can sell. That's simple business logic, right? And like any other business, they want to pay as little as possible for that. And what they have managed to do here is, in a way, brilliant. They've managed to reduce the price of content on YouTube and other similar unlicensed sites down to zero, right? And they've done that by lobbying for a change in the way IP rights are enforced. Now, that's perfectly easy to understand. What's a little bit harder to understand is why do courts, why did Congress, why do antitrust agencies, why did they sign up to this idea that IP rights are good for society, for the public in general? And that's where this accidental alliance comes in. So right around the mid 2000s, there develops out of academia in the advocacy community something that I call the information wants to be free school of thought, which sounds great, right? We all like to share. We're all taught to share. Sharing is good, right? But sharing doesn't work for all business entities in the market over the long term. And what sites like YouTube, I don't mean to just pick on one, there's other examples. What they're ultimately doing is not sharing, it's free riding. It's taking content and tech that's been produced by others, paying little or nothing for it, and reaping the rewards through the sales of ads and other revenues. So it's the package together, the information wants to be free school of thought that persuaded policymakers that expanding exemptions to copyright infringement, limiting the ability to get injunctions, all these things were good for society. And this book tries to argue not only why that happened, but the harder argument, why is that not a good idea for society in the long term?
When I read your book, my understanding is those big tech, let's call them the big tech companies, they also, as you just said, invest a lot in R&D. And so I checked online and try to better understand, they also file intellectual property rights. So on one hand, they are trying to weaken the system. On the other hand, they are also filing some IPR.
Yeah.
Is that compatible or?
Yeah. Well, there's a couple of things going on here, right? And I again, I want to recognize that not all of the platforms, but most of the largest platforms that we're familiar with invest significant amounts in R&D. Not as significant actually, percentage-wise, as some of the innovators that I'm sure we'll get to that rely on patent portfolios, right? But while they may invest in applying for patents as defensive measures, they're mostly monetizing their R&D by incorporating that, integrating that into a bundled product services ecosystem. So let's take another example to make this concrete. Google is an innovator in the search market, right? The PageRank algorithm, which was actually patented and then licensed from Stanford University. But since then, they are continuously innovating in the search market, right? But their strategy is a secrecy-based strategy. It's a speed to market strategy. And so they're not as dependent on IP rights and they may, for reasons perhaps we'll get into, they prefer an environment in which IP rights are weak. Now let's contrast that with a company like Qualcomm, right? Qualcomm is not integrating that into a bundled ecosystem. They are selling that IP out in the market through licenses and that requires IP rights in order to distribute that technology broadly, right? So on the one hand, the platforms are operating within a bundled ecosystem, a walled gardens model. Other innovators in the ecosystem, which also play vital roles, they're distributing that technology broadly in the market. Something else that I talk about in the book, which I think is overlooked, which is that IP rights don't just incentivize innovation, they enable transactions, they enable markets that distribute technology widely. And that's what most people recognize be a good thing.
So I better understand that. So some of those companies are saying IP rights are good as long as they belong to me, but the IPRs of the others are not so good and should be weakened. But it doesn't explain what are no, or why are I mean the big tech have been able, what you explain in your book, to convince courts, Congress, and antitrust agencies, and why have the arguments made by big tech been widely adopted by them?
Yeah,
How come?
well, in the short term, when we make IP rights weaker, right, we tend to reduce the prices, right? We could eliminate patents on drugs tomorrow, and the price of drugs would plummet. We'd have a flood of generics would come into the market, right? And that may be a politically popular decision for a policymaker to make. But we also know, and let's stick with the life sciences, where the empirical evidence is incredibly strong that when you weaken IP rights, specifically you weaken patents in pharma, you put price controls on pharma. Well, guess what? You have less capital going into the life sciences, or your drug innovation becomes incremental, becomes low cost, becomes low risk, right? Uh, and it's always easier to argue against IP. It's always easier to argue for weaker IP rights because you get that kind of sugar high, is an analogy I sometimes use, because you are going to reduce the price in the short term. But you pay a price in the medium to long term because, as is widely recognized, innovation, like any market, there's got to be property rights in the system somewhere, right? Because otherwise, everyone's going to choose to imitate. No one will choose to invent, and our innovation pipeline is going to slow down.
Okay, I better understand. But in the book, you describe third IP myth, which was a fun part for me. The IP myth concerning both copyright and patents that persist in scholarly and policy discussions. What are
Yeah,
some of those myths? And why do you
Sure.
feel they persist?
Sure. Part of the you asked me at the beginning of our conversation why I wrote the book, and one of the reasons I wrote the book was that I feel there's a group think phenomenon in our policy discussions, in our scholarly discussions in IP. And what I try to do in the book, and this took an immense amount of time, was to look at a number of common beliefs about IP rights, both in copyright and patent, and actually to go one by one through every single study that related to those common beliefs. And what I found, and I'll give you some examples, is that those beliefs often rest on a very weak evidentiary basis, or actually they're entirely wrong. So let's take an example. So sticking with the life sciences, when patent protection was extended by US courts and the patent agency to biotech innovations, it was widely predicted that patents would proliferate and innovation would slow down because you'd have to be engaged in licensing and litigation and so forth. And this is sometimes known as the patent thicket thesis or the anti-commons thesis. And there's a particular paper that makes this assertion, and it's been cited thousands of times, and it's the most cited paper in the patent thicket literature. But empirical studies that have gone out into the market and surveyed researchers and used other methods can't find evidence of the patent thicket thesis. They don't find that innovation is slowing down. And now, if you drill down just a little bit more and you actually go out into the market, like the trade press does, or some business management scholars, what you find is actually, the extension of patents into biotech was one of the most brilliant and beneficial policy choices ever, right? Let me give you an example. One of the first biotech patents was issued to Stanford University called the Cohen-Boyer patent. This is for recombinant DNA research tool, also known as gene splicing. Stanford then licensed that out to hundreds of companies producing thousands of therapies. That patent was issued in 1976, very controversial at the time. Only 6 years later, in 1982, the very first biotechnologically engineered pharmaceutical comes out, that's synthetic insulin. You expand access to technology, contrary to the reducing access effect that is often associated with patents. That's that market making effect I was talking about. The patents induced investment into life sciences. Why? Well, one, it gives you that exclusivity that enables you to get money back for taking on all the costs and risks. But the other thing that happens, it created a whole market in biotech, all kinds of transactions, startups, VC firms, pharma, all of that flowered on the basis of the patent system. And therefore, people who are actually in biotech are probably not surprised to learn that, in fact, the patent thicket thesis, which continues to be widely asserted, in fact, has very little foundation in reality. And there are many other examples that we could get to. We'll see if we have time.
What I like in your book is you provide a lot of anecdotes, stories, uh, and you explain things very clearly. I mean, in a simple manner. So you don't need to be an IP expert to really understand what you're saying in the book. But at the end of the day, yes, it is much easier to destroy the idea of the role of IP than to contribute and build and explain the benefits and the role of IPR. But the principal justification for IP rights is an incentive argument grounded in the free rider problem. That's my understanding. Yet you argue that IP rights also play what you call an enabling or transactional function. Can you explain what what is that and why it is so important? Maybe with other examples.
Sure, absolutely. So the incentive function is clearly one of the main functions that IP rights perform. Again, they create a property right They block imitators, and they enable the innovator to earn a return on their investment. And just as important, allows the investors in the innovator to earn a return on their investment. And that's critical, right? Because any innovation economy is built on the entrepreneurs, on the inventors, but also the VC money coming in. But it has this other function that you're referencing, which I call the enabling function or the transactional function. This goes back to an idea that was usually attributed to a Nobel Prize winning economist named Kenneth Arrow at Stanford University. He wrote a paper back in the 60s about something called the information paradox. What he was pointing out is that when we try and do deals over informational goods, technologies, it's different than physical goods. Because in order for you and I to enter into a transaction, let's say you're a VC firm, about how much you're going to invest, what are the other terms? Of course, you'd like to know something about my technology. But in the course of revealing information about that technology, in the extreme case where I tell you everything, the price that you're willing to pay for that, Kenneth Arrow pointed out, would be exactly zero. A property right resolves that problem. It takes the technology and it sticks it inside what I call a property envelope. Now I can stick that property envelope on the negotiating table, and you and I can start to do a deal. We can start to talk about the terms of the transaction. Let me go back to that Cohen-Boyer story. Well, the Cohen-Boyer team, one member of that team, went out to a VC firm and got money. They then partner with Eli Lilly. Why would they do that? Because you need hundreds of millions of dollars to do the testing and production, and a scientist found that startup's not able to do that. On that first product, synthetic human insulin, the patent played that dual role. When it hit the shelf, it blocked imitators from coming in, allowing the VC firm to get money. But it also enabled the transaction with Eli Lilly, which accelerated getting that product into the market. Why? Because it protected the scientist inventor from being expropriated by Eli Lilly. It allowed that partnership to develop. That accelerated the product's time to market. It reduced production costs, testing costs by orders of magnitude. That was the template for the biotech industry. We've seen this happen over and over again. If we move over to the IT industry, we see the same dynamic. Let's take the wireless industry, because I know that's an important industry in Europe and an area where there's some European companies that are leaders, that are critical, right? And why are IP rights critical to those companies that lead in Europe on wireless tech design, chip design? Because they rely on a licensing model. A licensing model necessitates IP rights because not only is it only a one-to-one transaction like the scientist in Eli Lilly, but if you are what I call an idea factory, you're a chip design firm in the wireless supply chain, you're entering into tens, if not hundreds, of licensing transactions with device producers all around the world. That's that market making effect. It delivers returns back up to the innovator. That's what we usually associate with IP rights, and it's correct. But look what else happens, staying with the wireless example. You've just distributed that technology to hundreds of firms around the world. So you get a policy win on innovation, but it also makes markets more competitive. People find this counterintuitive. Why is that? Because the device producer doesn't have to reinvent the wheel. Their entry costs have been lowered. They pay the royalty fee, and they have access to all the technology they need to enter into the wireless communications market. You've also reduced entry costs for the chip design firm. Why? Because they don't have to set up a factory to produce devices. So you get this amazing division of labor, this globalized division of labor that reduces entry costs for innovators, reduces entry costs for producers, and the winner at the end of the day It's the consumer. Because the consumer is benefiting from getting that innovation embedded in those devices faster than would otherwise be possible. And in a competitive market where there's lots of producers or lots of producers able to enter that market. Uh, and the wireless market is a great example of how IP rights have not only incentivized innovation, they form the infrastructure, they form the skeleton of the market itself.
Yeah, what's amazing here is you gave two examples. I mean, the first one what was about the insulin. I mean, we know that millions, millions of people are relying on insulin, and this is your patent story, success story that is benefiting everybody on Earth. And then the second one is relying on the standardization framework, which is misunderstood as well, where you have standardization enabling interoperability and creating success. I think those two are not understood as being same success stories. But the truth is, we are all benefiting. Everybody on Earth is actually benefiting from both examples you just gave. That's amazing. But among the many legal and policy decisions you discuss in the book, what were the single biggest policy errors in patent and copyright law? Or
All right.
how can those errors best be corrected by policymakers today, if I may?
All right. Number one on my list on the patent side, it's the eBay decision back in 2006. And just for viewers who are unfamiliar with this decision, until that decision under US patent law, if you defended the validity of your patent in court and you demonstrated infringement, except for extreme cases of public health emergency or something of that sort, you were entitled to an injunction. And that's not surprising because if a patent is construed as a type of property right, the essence of a property right is that you get to decide who uses your property. eBay introduced a four-part test that gave judges more latitude to deny injunctions in many cases and to only award monetary damages. Judges have interpreted that decision liberally, broadly, so that today it is not an exaggeration to say that outside of the life sciences space, patent owners in the US market today have a low expectation of ever being able to secure an injunction against even someone who is using that and profiting from it. And let me explain why this rigs the playing field in favor of imitators and in favor of some of the largest corporations in the world. So let me go back to that wireless market. Again, I know that's important in the European space. So we'd gone through earlier why the wireless market, the innovators in the market, right? And just to clarify for our audience, the innovators in the market are not the device makers that have that customer relationship, not the powerful brands are familiar with. They're aggregating that technology. They're integrating it. That's a platform role. Again, the platforms are important. But the platforms are not the primary innovators of the wireless communications technology that makes the whole system work. Who is responsible for that? It's actually amazingly in the West, a handful of companies located in the US and Europe. And here's what else is really interesting. Every one of those innovator companies spend in excess of 1/5 of their sales revenues on R&D. How do they monetize that? How is that rational? How do they defend that to shareholders? Through a licensing model. The licensing model, rooted in IP rights, delivers returns that are then plowed right back into R&D, pushing the innovation frontier forward. Now, what happens when you make it difficult or almost impossible for these innovators, the ones who are sitting at the very top of the tech supply chain, you make it difficult for them to get an injunction? Well, some of the largest licensees, largest device makers, are also some of the largest companies in the world. And since they have a very low expectation of ever being denied access to technology, guess what their rational business strategy is? To use that technology and wait to be sued. They then have leverage over the innovator, right? You see how the world is turned upside down here, right? The imitator has leverage over the innovator. Why? Because the user, the implementer, is earning revenues on those device sales. But the innovator has already incurred all of the R&D costs with no money coming into the business. That unlevels the playing field. That causes what I sometimes call a reverse Robin Hood effect. Because what's happening is we're taking wealth away from a handful of companies in this particular market that are responsible for innovation, and we're handing that over to companies that are implementing innovation. That's why I think this is the most important policy error. It eats away at the property rights characteristic of a patent. And when you do that, all of that market making function, that transactional function, it starts to deteriorate. So that would be my one fix to restore the injunction as an almost always expectation if you have a valid and infringed patent.
Well, so that's not totally doomed and gloom, but what you're describing here is it is better to wait to be sued and to infringe on patent holders. And at the end, it will cost you less anyway. So there is no need to take a license right away and just wait. And you will make money. And maybe one day you will have to pay something, but you will never be blocked because of an injunction. That's the reality of today.
Exactly, and this kind of comes back to what in the wireless space, yeah, in the IT space in general, where injunctions are weak and the infringer has abundant cash resources to litigate indefinitely. In many cases, I would venture to say in most cases, their rational business choice is to use the technology, wait to be sued, and essentially what you're doing there is that you're driving the pricing of technology into the courts and away from the market. And I think it generally would be considered that's a far less efficient way to price out technology assets than it would be if we had secure property rights. Then licensing transactions are going to happen faster. You're going to have less litigation, and the technology's value will be reflected in licensing transactions that then deliver revenues back up to the entities that are fueling the innovation that keeps the train moving in the whole market.
For the audience, you can ask your question directly in the Q&A. And one of the question, which is more like a suggestion, uh, do you think that the IP community should just hire a PR agency to try to debunk and demystify everything that you explain in your book?
Well, I don't have a particular view about the best way to get the message out. I've tried my best in the book to marshal the evidence here of why the IP system in its current form is favoring one part of the ecosystem um, over other stakeholders. And ultimately, the message in the book is that the IP system should allow the market to choose the best business model, right? There's a whole variety of business models. There's closed sources, open source, things in between. There's all sorts of reasons that businesses choose one over the other. When you weaken property rights, weaken IP rights, you favor one business model over the other. And that one particular business model, the platform-based business model, the giveaway business model, what it does is that makes markets less competitive, right? Because it favors business models that monetizes R&D within a walled garden, within a single ecosystem. Again, contrast that with the licensing-based business models that push out technology to anyone who's willing to pay the royalty fee. It's a more competitive market structure. I'm not saying it's always the best market structure, but it should be a structure that's available for the market to evolve towards if it suits a particular technology or particular product.
Okay. So let's try to dig a little bit more. So you argue that weakening IP rights poses a risk to the US innovation economy. And there is no doubt from your explanation, European policymakers today are focused on competitiveness. What does your book imply about the role of IP rights in developing policies that improve European competitiveness? Maybe focus on one or two sectors?
Yeah, sure. This is an easy case to make. And the reason it's an easy case to make is that if you look at the sectors right now where Europe is strong on innovation, okay, that's pharma, okay, and that's the sector I mentioned earlier. That's wireless technology, right? And why is it an easy case to make? Because in pharma, as I think I had mentioned previously, the empirical case for the necessity of IP rights to sustain innovation is remarkably strong. There simply is, to my knowledge, no business model out there in pharma that is not dependent on strong IP rights. And so if Europe wants to maintain and bolster its innovation strength where it's already strong, the case in pharma is easy. The case is similarly easy over in wireless for the reason, as I'd mentioned, that the companies in Europe that are strong in wireless innovation all rely on licensing models. And again, licensing models by definition rely um, on secure IP rights. The last point I would mention on from the European perspective is what about other areas? Well, a piece of evidence I would point out to European policymakers is that we do have evidence, and this is sometimes seems counterintuitive, that smaller firms, at least in certain technology areas, benefit from strong patent rights. Okay? And why is that the case? Well, the reason that's the case is if you go back to my biotech example, what did the scientists found at startup have there that the big firms didn't, like Eli Lilly? Only one thing, an idea. On every other element of the supply chain, testing, production, marketing, that individual entrepreneur cannot compete. But with a patent in his hand, the entrepreneur, that playing field is now leveled. I just talked about why when we weaken patent rights, we unlevel the playing field in wireless and we favor the larger implementers. Well, that implies that when patent rights are stronger, we empower the innovator, we re-level the playing field, we allow the innovator to reap returns in negotiating against large firms. And I just want to give you evidence to show that this is not just theory. I talk about this in the book, and the full analysis is in the previous book you had mentioned in the 2021 book. And what I show there is that in the United States, from roughly the 50s all the way through the 70s, there was a weak patent system. Did innovation stop? No, it didn't. But it occurred mostly inside big firms, Bell Labs, AT&T, RCA, if people still remember these companies. Okay. Throughout that period, from 1957, when the data started being collected, all the way through 1980, when the patent system was strengthened again, small firms accounted for roughly 5% of all R&D spend in the private R&D spend in the United States. In 1980, a number of policy actions strengthened the patent system in the United States. If you fast forward to 2025, roughly 1/4 of all private R&D expenditures are being undertaken, are being made by small firms. What that suggests is that the patents empowered small firms, which in turn allowed them to make the case to VC investors to invest money in small firms. It allowed innovation capital to flow away from large firms into smaller firms where it was now viable to undertake innovation. What that tells you again is that, again, this is counterintuitive. Not only do IP rights support innovation, they support competitive innovation markets. And small firms in particular play an especially important role. If you look at technology history, not all of the time, but much of the time, what is sometimes known as disruptive innovation, innovation that doesn't just tweak the paradigm, but it shatters the paradigm, comes up with something new, that comes from outside the big firm. And it looks like, not in all industries, but in many industries, IP rights play a role in that. And it makes sense why they would play a role. Again, they level the playing field, they allow the innovator to extract value on the innovation, even though they operate at a disadvantage at every other element of the supply chain going to market.
That's very interesting. But I have a follow-up question to your answer. Can we draw any lessons specifically concerning proposals in Europe? And my example is, the one is that he's proposing to establish an administrative structure to govern the licensing of standard essential patents and adjudication of licensing disputes.
Yeah, I think that would be going in the wrong direction, right? What we want to move towards, and I'm going to give you some reasons from technology history to show why this is the case. What we want to move towards is a system of secure intellectual property rights. When those intellectual property rights are secure, they induce the market to enter into licensing structures so that innovation is priced in the market. It's not priced in courts. It's not priced in regulatory agencies. It's not subject to lobbying. It's not subject to regulatory capture. Now, I know there's a reasonable objection out there to what I just said, which is, well, in the IT space, there's thousands of patents that read on a particular standard. Isn't the market just going to drown in litigation, drown in licensing negotiations? Now, that hypothetical objection I just raised is the same exact objection that that criticism that I described earlier when patents were introduced in the biotech market. And we know from the biotech market that they've done a wonderful job of using those rights to build licensing transactions that enable innovation. If we look at the IT space and we look at tech history, which has been wrestling with this potential problem posed by many, many IP rights reading on many technologies. What we find, at least in the United States, is that markets have shown remarkable capacity to come up with creative licensing solutions, cross-licensing solutions, patent pools that reduce transaction costs of licensing, and at the same time, they enable returns to be paid to the innovators who are part of that pool. And again, you get that virtuous cycle that I described earlier. The licensing revenues come in, it's put back into R&D, and the innovation frontier keeps being pushed forward. So I think on that particular proposal, it'd be better to go in the direction of actually bolstering IP rights, making IP rights more secure, more clarity. That gives the market the ability to start building out the licensing structures, the pooling structures, and in the wireless space, we have both of those things going on, especially actually on the pooling and the automotive area. Markets can come up with solutions, usually on their own, to these potential transactional roadblocks. The only thing they really need from the government or from the state is for those IP rights to be clear and to be secure.
Very clear. But at the beginning of this webinar, you discussed about digital piracy, and you said that it hurts a lot of content industries and the courts and Congress in the US. courts and Congress have failed to bolster copyright protections. Yet digital streaming now seems to thrive. So doesn't that show that IP rights are not really necessary?
Yeah, so let's look at something more interesting than more glamorous than wireless tech, although I love that myself. Let's go over to the music market, right? Let's go back to 1989. We've got Napster launching out of a college dorm. Now you get all of the CDs in Tower Records. You had to pay 15.99 for a CD. Couldn't get a single usually. It's all now free. Okay. And the courts initially shut down Napster, but other decisions, as I get into in the book, make it very difficult to enforce copyright in the digital area, and piracy proliferates. Unsurprisingly, recorded music revenues plunge. But as you know, that's not the case in the music industry today. Those recorded music revenues plunge, but they start to increase upwards, and the music industry is healthy. So does that contradict my thesis? Not at all. Because even though Congress has not stepped in to override the court's decisions that are generous towards platform aggregators, the market itself came up with technology that mimics to some extent that missing property right? So if you go on to Spotify, if you don't choose the ad-free option, right, and other music services, these are subscription-based models. You have technology regulating access. If you go over to other media, Netflix, ebooks, virtually every single digital content market that is working today has renewed property rights through technology. And I think that's just business common sense, right? The access has to be priced somewhere in order to maintain that revenue flow to compensate the creators, and just as importantly, to compensate the investors and the creators that stand behind it. So I think that's consistent with the thesis that IP rights, like property rights in any other market, they support markets, they support investment, and you see that happening in the recovery of the digital content markets. They recover when they're able to regain some control over their creative assets.
That's very interesting. Yeah, indeed, the market is providing solutions because I remember was it in 1996, 1995, people started to record videos in a theater and then to publish their recorded movie on the internet. And people were downloading these things where you could not see anything. And it was crazy. Um, yeah, so you can always imagine a worse scenario, but now for a reasonable amount of money, you can access unlimited quantity of movies or music, and it is indeed thriving. But let's get back to something that is really trendy at the moment, AI. And we all know that AI and copyright. There was some Altman that said that um, ChatGPT, they argued the fact that copyright is incompatible with AI development. They say that use of copyrighted works is fair use. Yeah, okay. But similar arguments are now being made to support UK legislation that will put the burden on copyright owners to opt out, the famous opt out, for text or data mining exemption for AI training purposes, something that just took force in the EU. Is there any reason to be skeptical about the positions being taken by AI model companies?
Yeah, so this is back to the future for the copyright debates, because we're really recapitulating the exact same debates that occurred right after the launch of sites like Napster, right? You had on the one hand tech arguing at that time that if you were to enforce copyright rigorously, the internet would not be able to grow. And that argument prevailed at that time. But again, that's a wealth shifting effect, right? You're taking wealth away from content innovators, and you're putting it in the pocket of those who aggregate content and earn sales from ads and other proprietary services. And we have that same debate today going on, and it's easy to predict what, and to understand the business interests behind tech and content, why one side wants IP rights to be stronger and the other wants them to be weak. But the debate today is different for two reasons, one of which is global and one of which is specific to the US. So the difference today is that back in 1999, early 2000s, those companies, the equivalent of the platforms back then, they were startups, right? And so the equities, the public perception favored them in the public debate. But today, you have AI model developers, both the independent and the platforms. These companies are spending billions of dollars on buying compute power, buying chips, and so it tends to strain plausibility why they are not able, for some reason, to pay for the content that is necessary to perform to support the training segment of the AI process. Specific to the US, there was a decision by the Supreme Court back in 2023 that actually cut back on fair use. It sort of admonished the lower courts for overly expansive fair use. And so I hope today that we can have a more balanced debate, right? I'd mentioned earlier in the tech context that we want to have an IP system that serves everyone in the ecosystem. We want innovators served, implementers served, platforms, everyone to be served. The same thing in the content space and AI, right? There are legitimate concerns raised by the model developers about the transaction costs, right? But there are at least equally legitimate concerns from the side of the content innovators, the content owners. There has to be a business model and a property right structure that enables revenue to flow to the content innovators. Otherwise, your content pipeline either is going to run dry or you're just going to have thousands of paywalled sites.
Yeah, at one point you talked about the doubts that some people have expressed regarding a strong IP rights, and we try to debunk it by giving examples. But um, you know, in particular, patents, people are really going against patents, or some people are going against patents because they don't see how useful it is, and it is easy to say, "Oh, this is just a right that allows to exclude." But it brings so much more, and that's misunderstood. Um, so, what do you think about patent litigation funding? If just imagine if small companies were helped to fund actually patent litigation, will it fix the issue, or that will not be a solution?
Yeah, litigation funding, when it's used appropriately, helps to re-level the playing field, especially in the United States, at least, where injunctions are not a real possibility anymore, right? That means that the only way to defend your technology through the patent system, if that's your IP strategy, right, is a protracted litigation. And if it's also the case that the infringer or implementer has abundant litigation resources, the only way to maintain a meaningful patent right in that no injunction situation is to have some external source of litigation funding. Otherwise, the patent becomes a piece of paper for smaller innovators. It simply doesn't have any economic value to it, at least in an environment where an injunction is not available.
So now let's take the opposite position where I heard commentators and policymakers saying, oh, patents are just raising entry barriers for the smaller companies, the smaller firms, and it even entrench incumbents. So what implications does your book have for those concerns?
Yeah, well, those concerns, which are reasonable, they're widely voiced. I would encourage those who voice those concerns to take a look at a piece of data that I have in this book, which looks at the lobbying and the advocacy activity on the part of all different kinds of industries, all different sizes of firms, concerning patents, going back to the early 2000s, including the litigation around the American Invents Act. Now, if it's the case that patents entrench incumbents in large firms, then why is it the case that when we look at their lobbying and their advocacy activity outside of pharma, they lobby against patents? They lobbied for the American Invents Act that weakens patents. They lobbied for the American Invents Act that set up the Patent Trial and Appeals Board, and they are now the largest users of the Patent Trial and Appeals Board, which invalidates patents. What that suggests is that while it's intuitive to think that patents would protect incumbents and therefore they would favor them, and therefore they raise barriers to entry for smaller firms, their lobbying behavior suggests that that is not what they think. They think that patents are either unnecessary or patents actually, in some cases, they threaten incumbents. And why would that be the case? Well, that goes back to a point that I made earlier. Because in markets where it is expensive to convert a technology into a product, where it can take tens of millions or hundreds of millions of dollars in several years to convert a technology into a product that is available, that is commercially and technical feasible, the patent is necessary for the smaller firm precisely in order to attract the funding, enter into the partnerships to convert that biotech technology, that pharma technology, to convert that into a product. That's not necessarily the case for the larger firm. The larger firm can do much of that, sometimes all of that in-house. It can be self-financed. They have the production facility, they have the distribution facility. So in markets where it is costly and it takes a long time to convert technology into products, patents tend to have the exact opposite effect that we associate with them. They don't raise entry barriers. Actually, they reduce them, um, uh, um, for smaller firms in particular.
On this, I would say, positive note, now we are approaching the end of this webinar, but you have explained so many things in a very simple, using very simple terms. I can only recommend to all the participants to this webinar to go to the 4IP website, go to the research tab, and then start reading the summaries of each chapter of your book. And I'm sure then they will jump and buy your book because all the anecdotes, all the backstories that you are telling are amazing. Uh, Thank you very much. Thank you very much, Jonathan, for sharing your knowledge, your expertise, and for all the work that you have done on this topic. I would like to thank also all the attendees. As you know, the recording of this webinar will be published maybe today or tomorrow on the 4IP Council's website. Please don't forget to subscribe to our newsletter because very soon, next month, we'll have a new webinar which is based on a paper that is called The Law and Political Economy of EU Legislation by Natalia Menendez Gonzalez, Nicolo Galli, and Marco Botta. The registration is not yet open, but please just follow the website, the newsletter, and you will be told when it is published. So please, if you receive just a very short survey to provide your feedback regarding this webinar, just 1 minute, please answer it. And Jonathan Barnett, thank you very much for your participation. I
Thank
really
you. Thank
appreciate this
you.
discussion. I hope that things will get better and all the proposals that you are making in your book will open the eyes of policymakers.
Thank you so much. Great talking to you today.
Thank you. Have a great day.